Corporate trustee duties are complex and highly scrutinized. Why? When a trust is particularly large or contains a complex mix of assets and investments, real estate, businesses, and tax considerations that go along with them, a corporate trustee is often appointed instead of a family member or a family friend. Corporate trustees are usually banks, institutions, or trust companies. They have the same fiduciary duties as any other trustee, but are sometimes subject to heightened legal risk. In the next couple minutes, I want to talk about the many professional obligations and responsibilities of corporate trustees and some common reasons they get sued or removed for breaching fiduciary duties. What are the legal duties of a corporate trustee? While specific corporate trustee laws may vary a bit from state to state, in almost every state, a corporate trustee has the following fiduciary duties owed to the trust and its beneficiaries. First, duty of loyalty. A corporate trustee must never place their own self-interest above what's best for the trust and its beneficiaries. They must refrain from self-dealing and disclose and avoid any conflicts of interest. Second, duty of administration. A corporate trustee must administer the trust in accordance with its terms and provisions. Third, duty to furnish information. A corporate trustee must keep all parties to the trust reasonably informed of any material facts regarding its administration and management. Fourth, duty of impartiality. A corporate trustee must never show preferential treatment to one beneficiary over another. Fifth, duty to enforce and defend claims. A corporate trustee must defend the trust against any legal action taken against it and must proactively seek to recover monies the trust has wrongfully lost. Sixth, duty of prudent investment. A corporate trustee must make appropriate investment decisions with the trust money. They must not subject trust assets to undue risk or fail to reinvest or diversify the assets as needed. Seventh, duty to keep trust property separate and maintain adequate records. A corporate trustee must never commingle funds and must always keep a full and up-to-date accounting of trust assets. Eighth, duty to control and protect property. A corporate trustee must take steps to secure and protect all assets held in the trust. Ninth, duty not to delegate. And this is an important one. Every trustee must generally not delegate any tasks that they owe to the trust and its beneficiaries to another party if they could perform the tasks themselves. But note that many states now allow delegation for certain tasks, such as investment management. But that does not mean that they don't have a duty to oversee the person that they're delegating that task to. What does a corporate trustee do? In the course of their duties, corporate trustees will generally do all the following. First, manage and administer the trust according to its terms and intent. This includes making distributions to beneficiaries, managing the trust investments, filing trust taxes, selling property or real estate as instructed, paying any debts or creditors, and keeping an accounting of the trust. Second, communicate with co-trustees and beneficiaries and give them timely written or other notice and disclosure of any relevant information pertaining to the trust and its administration. Third, use sophisticated tax planning strategies to minimize tax liability to beneficiaries and trust accounts and assets. Fourth, monitor investment performance and diversify as needed to maintain and make the most value out of those trust assets. Fifth, file claims and collect proceeds on any life insurance or any other assets. Sixth, make referrals or hire professionals as needed to ensure that the trust is protected and as profitable as possible. Seventh, staying up to date on state and federal trust laws, rules, and regulations, and making sure they're abiding by them. What are some common reasons corporate trustees get sued? The reality is, corporate trustees get sued all the time. Some common claims corporate trustees contend with include, first, mishandling or mismanagement of assets. Second, self-dealing. But note that corporate trustees are generally allowed to invest in their own proprietary products. Third, conflicts of interest. Fourth, failure to diversify investments. Fifth, improper or simply failing to account. Sixth, failure to take advantage of tax planning opportunities. Corporate trustees are often subject to internal regulation as well, so it's more rare for them to actually steal, divert, or embezzle trust funds, but it can and has happened, especially when there's relatively little oversight from beneficiaries or co-trustees. Why do corporate trustees get sued? Whatever the actual legal basis is for a corporate trustee to get sued, the underlying reason, more often than not, is that the beneficiaries, creditors, or co-trustees don't have a close or trusting relationship with the person who's now controlling the estate. Corporate trustees are often appointed by the trust creator because they had a close personal relationship with their banker, estate planner, wealth manager, or financial advisor. But the heirs, the beneficiaries of that trust, likely don't have the same faith in the person that their mom or dad or loved one did. Or sometimes, expansion at the corporate trustee's employer results in impersonal, unresponsive, or overly passive trust management and a lack of communication. Unless corporate trustees communicate proactively with the trust beneficiaries and remain directly accessible and accountable, that lack of personal tie is going to put them at greater risk of being removed and facing claims of fiduciary breach. Can corporate trustees pay their legal fees out of the trust? Most often, yes. Most trusts contain provisions expressly authorizing a trustee to use trust funds to defend themselves and the trust in a potential lawsuit, even one that involves the trustee. These provisions often allow corporate trustees to advance funds from the trust to pay for their attorney's fees. But if settlement negotiations or a court concludes that the corporate trustee's own negligence or misconduct caused the loss, the offending trustee generally will be ordered to pay legal fees out of their own pocket. This might mean reimbursing the trust for monies that they already took to pay for fees, or relinquishing the right to recoup legal fees that were already paid from their own assets. Can a corporate trustee be removed? Potentially, sure. Obviously, if the creator of the trust is still living, they might be persuaded to remove the corporate trustee themselves, which they almost always have the power to do as long as the trust is revocable, assuming, of course, that they're still of sound mind and have capacity. If they don't, their power of attorney might have the power to do that. But most of the time, a corporate trustee only takes over after the trust creator has become incapacitated or has passed away. This is why most modern trusts often contain provisions granting others the power to remove a corporate trustee and describing exactly how and when it can be done. A lot of older trusts don't contain these provisions. In those cases, the person wanting to remove the corporate trustee might first ask them to just voluntarily step down. If they won't step aside, then the only option you'll have is to file a lawsuit to have them removed. To succeed, you're going to have to prove that the corporate trustee somehow breached their fiduciary duty. Because corporate trustees have so many duties and handle so many different tasks, this may not be hard to prove. Any mistake by a corporate trustee could leave them open to removal. Can a corporate trustee be sued by a co-trustee? Yes. Co-trustees are often granted the power to remove a corporate trustee by the trust document itself. Many corporate trustees won't go down without a fight, and co-trustees are expected to be actively involved in trust administration and oversight. So if a co-trustee received proper notice of their co-trustee's actions, and why wouldn't they, since they have their own fiduciary duty to be informed about what's going on with the trust, but failed to intervene, it may be harder for them to succeed. However, if a corporate trustee acts in a rogue manner, such as engaging in fraud, embezzlement, or other knowing and willful conduct, a co-trustee will be more likely to succeed in their removal effort. Have questions about any of this? Give us a call, shoot us an email. The consultations are always free. Thanks for watching.